All right, Dick Armey, thank you very much, former Majority Leader. And here with perhaps a different point of view, a former State Department counselor, Philip Zelikow, who worked so closely for years during this period, in fact, with Condoleezza Rice. Thanks so much for joining us from the University of Virginia. Let's talk about what we knew then, what we know now, and what the importance is. You've had the Vice President, the former Vice President, Dick Cheney, saying that, suggesting that it was justified, that these techniques were justified because of what they produced. There's some dispute over what they produced, but are they justified depending on what results come out of these interrogations?
Well, there are two problems with that. The first is, yeah, you got a lot of intelligence from the program, but did you actually need these techniques to get the same intelligence results? What a lot of your viewers may not know is that we've been running an intelligence program against al-Qaeda in Iraq that operates under different rules and with different teams, and it's been very successful against al-Qaeda in Iraq. There's British experience to look at, Israeli experience to look at. We've fought wars before ourselves. This is a completely unprecedented program, and I think it turns out we didn't need this program and these extreme techniques to get the intelligence gain. But the other problem is the notion that we can, where does the argument end if we can do anything we want to people because we get some information that we need? I mean, Andrea, you'll remember even back in the 60s when the Supreme Court adopted the Miranda decision, people thought the sky would fall because police wouldn't be able to catch murderers anymore. But you don't hear people now arguing that we need to overrule Miranda. We can adapt, and we can get our institutions to work without having to adopt the techniques prefigured by George Orwell's 1984.
Would it work as an attorney? Do you think that there are people in the administration who should be subject to possible prosecution, whether it's those who've been looked at now, the authors of the original memos in the Justice Department? Federal Judge Jay Bybee has been one who's mentioned, John Yoo, Bradbury, and some of the other authors. Can you make a distinction legally between those who authored and authorized, guided this program, and those who actually carried it out? The distinction that the White House seems to now be making?
My answer to you, Andrea, is the same answer I would give to President Obama, which is step out of it. I should step out of it. President Obama should step out of it. There have been allegations that criminal activity occurred. Good. We have institutions to sort out those kinds of allegations. The Department of Justice, the Attorney General. We just had an election in which everyone agreed we shouldn't politicize the Department of Justice. We shouldn't tell the Attorney General for partisan reasons to prosecute or not prosecute people. In fact, let partisanship step out of it. Let professionals sort through the very complex facts here and the tough legal issues, and then come up with the conclusions they should. You know, this whole episode is one in which people wonder whether America was stepping back from its traditional institutions and its values. Let's solve this problem by showing confidence in our institutions.
Well, let me ask you what happened with you. Were you ever told, you wrote and argued internally against some of these practices and against some of the policies. Were you ever told to destroy memos? Did they try to silence you when you were in the State Department?
Well, there was, I was acting as an agent of Secretary Rice, and I wasn't silenced, and Secretary Rice wasn't silenced on these issues. But I want to be clear, is I did write one memo, among many. There was an argument going on policy grounds, legal grounds, but I did think these particular legal opinions that have recently been disclosed had legal arguments about American constitutional law that were extreme. I worked in this area of law many years earlier, and I felt obliged to at least get down on paper, folks, there's an alternative view here. I think this is a really extreme view of the Constitution that's not going to stand up in federal courts. Now, they may view my view as having been extreme, and they certainly thought my views were out of line. And that particular memo, folks did want to try to have collected and destroyed.
So, folks wanted you to, I'm sorry, I've got to ask you that again because I didn't quite hear your complete answer. Folks wanted you to get rid of that memo? If you could clarify exactly what happened, who told you to get rid of your memos?
I distributed my memo that had an alternative view of the Justice Department's interpretation of constitutional law, that argued that their view was extreme. I got word back from another meeting from one of my colleagues at the State Department who said, hey, the White House wants all the copies of your memo collected and destroyed. Now, we did not destroy the copies certainly that I had at the State Department, but I think they thought my memo was out of line, that it was the Justice Department's job to write on these issues, and that I had spoken out of turn, and that not only was the piece of paper wrong, it was inconvenient to have it around.
Inconvenient to have around. Philip Zelikow, one of the people who was arguing against the justification for the so-called enhanced interrogation techniques. Thank you very much for joining us today.
Oh, you're welcome.
And coming up next on Andrea Mitchell Report.